Yes, for the list.
For item number 1, pronouncement of judgment.
We find no infirmity in the said judgment and order, that is the impugned judgment and order. We affirm the same. The appeal is accordingly dismissed. We direct the appellant to comply with the impugned judgment and order of the learned single judge within 4 weeks of communication of this order.
Item number 2.
May it please, Lordship.
Yes. Yes, sir.
The power distribution company is challenging the order of learned single judge, my lord.
Yes.
The learned single judge, by the impugned judgment and order, has set aside the notice issued for demand against respondent number 3 and 4, my lord. These are two companies, Summit Digital and Reliance Geo-Info. The notices were sent to the respondent number 3 and 4 asking for payment of electricity dues that were challenged by the respondent herein.
Learned additional Solicitor General submitted on the last occasion.
Yes, my lord.
That his clients had never consumed that electricity.
No, the submission was, my lord, that the dues are not payable because of waterfall mechanism and the resolution plan has been accepted. Even though the electricity has been consumed by his client, I am not legally entitled to recover it because it is barred by the plan approved by the NCLT under IBC code, my lord. The case is that there is a resolution plan which was approved in favor of the petitioner before the learned single judge, my lord. The resolution plan is in favor of, my lord, Reliance Telecom Company, which later on became Reliance Infratel, my lord. Reliance Infratel filed a writ petition before the this honorable court, challenging the demand notice issued to Summit Digital and Reliance Geo-Infocom, stating that Reliance Summit Digital and Reliance Geo-Infocom are subsidiaries or affiliate of Reliance Infratel and no due payable before the cut-off date. If I can show, my lord, the prayer, my lord, kindly see the prayer at page 96.
In fact, my friend argued it on last occasion and we were pleased to clarify to this honorable court. Lord, these dues relate to me and they don't come to me, they go to my subsidiaries. And therefore, we are aggrieved and we have filed the writ petitions. These subsidiaries have not consumed this and these are not.
That is what I said. That is what I said.
Yes,
The Lordship rightly said it last occasion.
The issue is, my lord, if I can show the prayer, my lord, kindly see the prayer. My understanding, my lord, page 96. The prayer is, my lord, at page 106, I'm sorry, page 106. And kindly see prayer C, my lord. quash and set aside the impugned demand notice dated 12th June 23 to the extent that it pertains to the dues of petitioner number 1 prior to 22nd December 2022. Direct the respondent number 2 not to take any coercive action against petitioner and its affiliate, including respondent number 3 and 4, recovery of any purported dues of petitioner number 1, or may pass such orders. So the prayer, my lord, if your lordship will kindly appreciate that there is a demand notice which was raised on respondent number 3 and 4, and that demand notice, if your lordship will find at page next page only, my lord, page 109, after 2 pages, my lord, page 109.
No, the demand may have been raised
Yes, my
on
lord.
3 and 4,
Yes,
but it appears from the press
Yes, my lord.
that to the extent
Yes, my lord.
that demand relates to petitioner number 1
Yes, my lord.
prior to this period,
Yes, my lord.
that is to be quashed.
Yes, my lord. Now, the question which falls for your lordship's consideration is number 1. Demand has been raised on the independent juristic personality, that is at page 109, the Summit Digital Infrastructure Private Limited. Now, Summit Digital Infrastructure Private Limited is not approaching this honorable court for the relief that I am not liable to pay for the dues of petitioner prior to this cut-off date of 22nd December 22. The aggrieved party, in my understanding, and locus would be of the Summit Digital Infrastructure. Because Summit Digital Infrastructure would have maintained a case before your lordship, maintaining a stand that I am not liable to pay the dues of petitioner prior to 22nd December 2022. That could have been the case of the Summit. Petitioner cannot come and say that Summit Digital Infrastructure is not liable to pay my dues. Because ultimately the demand is from Summit Digital Infrastructure. And I have taken this plea, my lord, straight away in my writ petition and in my counter affidavit and everywhere, my lord. And that has not been dealt by the learned single judge at all, my lord. My contentions have been noted, but not adverted to.
Suppose, Mr. Advocate General, let us
Yes,
take
ma'am.
the case of 2 individuals.
Yes, my lord.
Say you and your junior.
Yes, my lord.
You are a consumer of electricity. Now the bill goes to your junior. So as long as those bills are not paid, as a consumer, you remain liable and continue to be liable.
Yes, my lord.
So you have an interest in a proper bill being raised upon you.
Yes, my lord.
Because upon consumption of electricity, you have made yourself liable to pay for
Yes,
it.
my lord.
Maybe the bill has been issued wrongly.
Yes, my lord.
So there you have an interest in early payment or punctual payment or entire payment of the bills
Yes, my lord.
to discharge your liability.
Yes, my lord.
That is one part of locus.
Yes, my lord.
And the second part is that has to be argued and examined.
Yes,
How
ma'am.
much a holding company has an interest
Yes, ma'am.
in the subsidiary.
Affiliate. What they use the term affiliate, my lord. Affiliate. Now, the both my junior and me both are independent legal personalities, my lord. Now, my junior is being billed, which my junior is not liable to pay. As a, my junior can,
It may be, Mr. Advocate, it is coextensive, right?
yes, my lord, but here
His right to avoid it and your right to make timely payment. Otherwise, your liability keeps on accruing.
no, my case here, my lord, if slightly different, is that the liability I have demanded from Summit Digital Infrastructure that you have to pay. Summit Digital Infrastructure is not saying that no, I am not liable to pay. Petitioner it was duties of the petitioner to pay it. Summit Digital Infrastructure is not before your lordship. There is no grievance of Summit Digital Infrastructure. Grievance is not raised by Summit Digital Infrastructure. It is being raised by the petitioner who says that Summit is my affiliate. Here, these are all independent juristic entities, my lord. My question to myself is that whether when the liability I am raising from juristic person and he is not coming, whether the second juristic person can say that no, summit is not liable to pay.
According to you, the liability is of the affiliates.
Yes, my lord, I have raised the demand and that is the demand which is being questioned before your lordship in the prayer. Page
According to
109.
you, this demand has been rightly raised.
Yes, my case is that demand has been rightly raised and if there was any grievance should have been of summit, not of the petitioner.
No, that is a different thing. But according to you, they are the consumers and
Yes, they are the, my case is that my case stands on two different footings. One, first is that summit is not before your lordship, therefore writ is not maintainable at the behest of the affiliate, at the behest of the parent. If they call it parent, to what extent their relationship is there, that is also not clear. To what extent summit is liable to pay or not liable to pay, but that is a second scope of examination by this honorable court, my lord.
yes.
Now, your lordship kindly see at 762, I have shown this notice, my lord, to submit digital infrastructure at page 109. And kindly note that, kindly see the notice to submit digital infrastructure. It has got two components also, my lord. Page 109. With reference to the subject cited above, I am to bring to your kind notice that 116 number of mobile towers having power supply with outstanding electricity dues of more than 5,000 only, each and other total outstanding dues against these consumers is 70,68,648 as on 31st May 23. Further, there are 60 number of mobile towers which were already been disconnected and total outstanding dues as on 31st May is 2.74,807. There are 18 number of mobile towers having power supply with outstanding electricity dues of 5 only or less without outstanding dues. The list of consumers outstanding dues are so and so. Below the list is annexed 2 and 3. Requested to kindly make necessary arrangement for payment of dues of live consumers having outstanding dues of more than 5,000 of disconnected consumers having so and so and compliance. And list is below. If you lordship will kindly see the list at page 1010. And serial number 1, my lord, and third column from the right side, my lord, is that tower company Reliance Jio and Reliance Telecom. Reliance Jio / Reliance Telecom. And lordship will see the memo parties, my lord, at page 74. Memo parties will also be find at page 74. Reliance Jio Infocom is response number 3 and Summit Digital Infrastructure Limited is 74. And we kindly see the pleading to this extent, my lord. Pleading at page 78. Paragraph 10 and 11, my lord. Paragraph 10, my lord, at page 78. The petition number 1 is a company incorporated under the Companies Act 1956, having its registered office at the address stated above. The petition number 2 is in the business of providing passive telecom infrastructure to wireless and other communication service provider, and is a company operates in 43,000 mobile towers across the country. The petitioner has 102 operational mobile towers in the state of Meghalaya. It is also important to state that prior to petitioner's takeover by Reliance Project and Property Management Solutions Limited under the Insolvency Code, petitioner was in no manner connected with Reliance Group of Companies, my lord. Now kindly, after describing this, my lord, on page 79, third line, my lord. Respondent number 3 is Reliance Jio Infocom, a telecom provider and affiliate of respondent number 1. And respondent number 4 is Summit Digital, is also affiliate of respondent number 1. Reliefs are claimed against respondent number 3 and 4. Reliefs are claimed against respondent number 3 and 4. So this is the total description, my lord. 3 and 4, my lord. To what extent, in what manner those dues are payable by petitioner, nothing has been described in the writ petition. Then, Your Lordship, I have taken the objection at page 762 in my counter affidavit.
You were acting as the principal for these service providers.
It's their case is that they are affiliate, my lord. I am the some companies.
No, they were acting as the principal.
Their case is that there is no clarity in the writ petition, my lord.
Can I clarify, Lord, in just 2 minutes so that the whole case can be put in a particular perspective. Otherwise, it will go in circles for days. Lord, I just put it in 3 sentences. Let my friend then shape the case. Lord, the petitioner is a successful resolution applicant in an IBC matter. Now, under the IBC law, while finalizing a resolution plan, the Act contemplates every statutory dues by authorities to be forming part of the plan, provided the authority approaches the resolution applicant, for which we are given public notices. The resolution professional has given public notices, made it known. Several bodies, including electricity boards, have all come and done it. This Meghalaya Electricity Board did not come forward to make their claim. So no claim was filed. So it could never have formed part of the resolution plan. Supreme Court said, once a resolution plan gets finalized, all liabilities get extinguished, including statutory liabilities. So if an authority does not file his claim before an RP, he loses his right to file a claim thereafter. This is what has happened in this case. So they did not file in spite of notice, and the resolution plan got finalized. After the plan got finalized, after the liability stands extinguished, they go to my subsidiaries, knowing fully well they can't come to me. Because their plan is finalized. According to the Supreme Court, it will be a violation of law if they come to me. For the very same dues against me, they go to the subsidiaries. And that is how, while my lord, this is a liability which is against me. This liability against me stands extinguished statutorily through a process of IBC. In terms of a Supreme Court judgment, an extinguished liability is rekindled through my subsidiary. And my subsidiary has filed a reply by clarifying, this is not my liability, you go to them. And they still chase. And my friend says, they should file a writ petition or not me. It is my liability. I am directly an aggrieved party. And you are opening up a Pandora box which is already closed. But this is the background of this whole proceeding. My friend should address this instead of saying he is entitled to argue what he wants to. But this will be searching the long tail. This is
I was trying to understand this notice at page 109. It talks about mobile towers, and then it talks about live consumers, use of live consumers in an annexure, and it says you pay that. So who are these live consumers? Are they to pay directly or through a principal?
Page 110.
Page 109.
This is answered in page 110. If the lordship comes to page 110, please see who are the live consumers. It is me.
Reliance Telecom, Reliance Telecom.
Please see the entire column. Tower company. Who is the tower company? Reliance Telecom Infratel. Please come forward. Yes. Lord,
No,
this letter is.
it mentions Reliance Jio Telecom. Live.
Yes, which is yes,
Now-
this is the petitioner.
Now, please see these breakup. Number one, Reliance. Number two, Reliance Infocom. Number two,
Yes.
Reliance something towers. Then Reliance.
Not Summit. Nothing is relating to Summit. Lord, they issue a notice to a subsidiary asking for the dues from which are dues against the petitioner. Simple case. Nothing is against the subsidiary. But we are not, but let me make it very clear and with a responsible statement. We are not fighting the subsidiaries' dues here. We are fighting our dues sought to be collected from the subsidiary, extinguished dues under due process of law.
So Reliance and Jio
What
are
does
you?
it say?
You.
Reliance Jio is respondent number 3 here, my lord.
Reliance Telecom is the
Telecom tower company is called the Reliance Telecom Infrastructure Limited (RTIL),
Which
is what-
they have taken over or acquired after, according to the further to the resolution plan.
Your lordship, if this, your lordship, I have seen, I have shown page 78, paragraph 11. One line statement is that they are my affiliate.
We don't deny that.
They are my
friend-
affiliate.
My friend is still not
And
answering
my
the question.
case is, my lord, my case in law is, my lord, that the demand, if they are affiliate and the affiliate are all independent legal entities, and they are not, as per the affiliate, they are not liable to pay, they can come before your lordship and say that I am not liable to pay for, and this is a wrong demand raised on me. It could not have been raised. This is one aspect of the matter, my lord. Let me show the pleading, my lord, to this on this.
Before my learned senior says, I just want to assist Mr. Venkatramani. While doing the writ matter, there was a specific order by the learned single judge on 18th October 23, which categorically directed my learned friend to disclose what are the dues as far as the respondent number 1 is concerned, because I was arguing that. So there was a specific order and there was a specific affidavit was to be filed. While they disclosed that affidavit, which is not on record in the writ appeal, they did not mention any dues as far as the writ petitioner was concerned.
My case, my lord, is that I am making if their case
Is
is,
it on record? We want to see all the papers.
Then
my case is, my lord, that if I am making a wrongful demand on an entity which is not liable to pay, then that entity, being a independent juristic person, can come forward and before your lordship and say that to this extent I am not liable, and in writ jurisdiction this issue will be adjudicated, that how much is liable to pay be paid, how much, because this involves determination of factual aspect also, my lord. It's not only because passing of the notice, my lord. And if your lordship will see, I have raised this precise argument before in the writ court also, my lord. Page 762, paragraph 13, my lord.
That affidavit was filed by you or them, which is not on record.
This is, my lord, all documents are there, my lord. If this record is 868,
Mr. Sastri,
868.
The affidavit is required to be filed by my learned friend client. There was an order of 18th October 23, which specifically states that we reply to the demand what is due qua me. So they were supposed to file and they filed.
It is on record also, my lord, 868, my lord. My friend has not seen properly the pages. But the lordship kindly see page
what is the date of the order?
18th October 23.
18th October 23, my lord. It is there on the record, my lord, page 868 of this paper book, my lord.
I stand corrected.
You have not seen. But kindly see this one paragraph at page 763. Let me place my case on this aspect, my lord.
No, where is that affidavit?
868, my lord.
Line of the petition, not the declare the respondent. 868 is our affidavit, not the state's evidence. So we have clarified as well.
I was showing, my lord, page 763, paragraph 15, my lord.
Not 863.
868, they say that the affidavit, that is.
This is the affidavit in reply.
This is additional affidavit but filed pursuant to the order of the learned single judge dated 18th October 23, my lord.
At page 868.
868, my lord. Annexure 8 and boldly listed.
Lord, may I just clarify? Lord, the state has not filed an affidavit. We have filed an affidavit which is at page, Lord, 886, my friend, annexure 868, annexure 810. And please see, my lord, at page 872, para 6. This is exactly what we have said. I state that despite the specific direction of this Honorable High Court dated 1/9/2023, the respondents have not filed any response to so-and-so 1/9 of 2023. That's our case. Para 10, Lord, please again come to para 10. I state there are no dues payable to the respondents in as much as the respondents, having failed to participate in the corporate insolvency resolution product, have waived its right, and accordingly the resolution plan so prepared is no binding. Lord, my friend's contention in law can be addressed in one, just so that we can lead the court, Lord, in the direction it is needed. Lord, my friend's contention is I am a non-party to this and I should be non-suited. My friend has to address only one question to your lordship. Then, my lord, everything will get resolved. The liability belongs to whom? And what happened to the liability qua the petitioner? And in spite of the fact that it belongs to me, why did he go to the respondent? He can't say, I have a right to issue it wrongfully. This is not a wrongful claim. A claim which stands extinguished under process of law is reactivated. And therefore, we are rushing to this court. It's a completely different background. It's what, my lord, we wanted to assist the court.
With greatest respect, my lord.
You please continue.
Yes, my lord. With the greatest respect, my lord. The claims are, in my case, is that even assuming that this resolution plan has been accepted, in resolution plan also my claims have not been extinguished. I will come to that part later on, my lord. I was on the issue that at page 763, my lord, why I am showing this paragraph, the reason is that they say that Reliance Infratel and respondent number 3 and 4 are affiliate of Reliance Infratel, my lord. I say that you have not disclosed any material in the writ petition. There is nothing to show that they are your affiliate, and there is no relation per se, my lord. And this ground I have taken at page 763, paragraph 15, my lord. It is submitted that there is no clarity, 763, paragraph 15, my lord. It is submitted that there is no clarity as to the inter se relationship between noticee, respondent number 3 and petitioner. Writ petition is vague and is liable to dismiss on this ground. It is also submitted that petitioner has stated that respondent 3 and 4 are affiliate of petitioner without disclosing any material. Moreover, respondent 3 and 4 are independent juristic persons and are capable of suing or being sued. Therefore, claim of respondent 2 against 3 and 4 cannot be agitated by petitioner company which are an independent juristic person. There is no cause of action in favor of petitioner. This was my plea, and there is no reply to this in the rejoinder, my lord. There is no response. And this was noted by learned single judge, my lord, at page 48, my lord. This plea of mine was recorded by learned single judge in the impugn order, my lord. At page
What has the learned single judge held?
despite recording my submission, no, it has not been adverted to. It has not been dealt. So therefore, the
I
order,
don't know, what is the finding?
there is no finding on this part.
No, then what is the order?
There is the order is silent. Order has gone only on one issue, whether the claims against the petitioner have been extinguished by virtue of the resolution plan or not, my lord.
The learned judge has held yes.
And the learned judge has that all claims have been extinguished and therefore you cannot make any claim against respondent 3 and 4 also. And so from the impugn order, kindly see page 48, paragraph 11. My submissions, my lord, in nutshell has been recorded, in crux has been recorded by learned single judge in paragraph 7, page 45. Paragraph 7. Third line. First, appearing respondent is follow. First, a resolution plan that ignores statutory duties is invalid and not binding. Secondly, a resolution plan does not provide for waiver of statutory dues. Thirdly, electricity dues are statutory in nature. Liability does not cease. And fourth, writ petition is not maintainable due to the presence of effective alternative remedy and is based on disputed question of fact as orders under challenge are against performer respondent 3 and 4. And then you lordship kindly see paragraph 11 at page 48. Arguments have also been advanced that writ is not maintainable as there exists disputed question of facts in as much as the order under challenge are against performance respondent 3 and 4. It is submitted petitioner has sought quashing of the recovery notice to performance respondent 3 and 4 that these respondents themselves have not approached this court to assert the same, meaning thereby they are not aggrieved, which would make the instant petition on behalf of respondent not maintainable in law. It has further been submitted that there are disputed question of fact and petitioner number 3 has not quantified the amount payable by 3 and 4 before the alleged cutoff date. It is also further submitted there is no clarity as to inter-se relation between 3 and the petitioner, which makes the writ petition vague and not maintainable. On this point, this is my submission, my lord. And the only issue learned single judge has decided in paragraph 13, if after recording this submission, my lord, learned single judge has not at all adverted to my submissions, my plea, my lord. And the issue framed in paragraph 13, my lord, is this. From the submissions and materials that have been placed before this court, the issue that arises for consideration is only whether the respondent corporation is entitled to recover the outstanding amounts from petition number 1 and its affiliates, respondent number 3 and 4, for the period prior to 22nd December 2002, that is effective date as per resolution plan, petitioner 1 was taken over. As discussed above, after petitioner number 1 was admitted to insolvency, a resolution plan which has been submitted was approved by National Company Law Tribunal and by Supreme Court, and the Reliance Project Property Management Solution took over the petitioner number 1 on 22nd December 22, section 30. And then, Your Lordship, the learned single judge goes into the issue that under the waterfall mechanism, all liabilities of the insolvent company are wiped out. My submission, which was recorded by learned single judge, has not at all been adverted, held by the learned single judge in the entire paragraph 13 to 19, Milord. So, in my humble submission, the order of the learned single judge is non-speaking on this point, Lord. As no reasons have been assigned by learned single judge in rejecting my plea, which was duly noted at paragraph 11 below.
We cannot hear it any further today.
Yes,
You please choose another date, Mr. Solicitor.
You will have to fix 18th, for the hearing 18th. 17th. Or
17 March.
That is Monday.
But if my friend wants it on 8 to complete it, let him complete it on 8. Let him complete. I need only
17, that
45 minutes.
is, that is this Monday.
Yes, Your Lordship has given 2 dates in this matter.
Yes, today and Monday.
Yes,
Yes,
today and Monday.
Yes, Monday at 3 p.m.
Yes, Lord. Grateful. Lord.
Keep your way.
We have heard Learned Advocate General for the appellants. Full stop. The arguments are not concluded. List this appeal for further hearing on 17th April, marked at 3 p.m.
17 March.
As the only matter in the list.
Grateful. Lord.
17
March.
Notice at 3 p.m.
17 March.
Yes, yes. That is Monday.
That is Monday.
Extremely obliged. Lord. Keep you.